Members, we can form a quorum with 4 members, so we have just formed a quorum. Let's start our meeting. This is the second meeting of the Bills Committee on Trust Law Amendment Bill 2013. And some more members may be joining us as we proceed. Apart from Secretariat staff, we are going to have a team from the administration. First item, minutes of meeting on the 1st of March 2013. The draft has been sent to members. So far, the Secretariat hasn't received any proposed amendment from members. So, does any member wish to propose amendments here and now? If not, I'll confirm the set of minutes. Next, meeting with the administration. Please ask the officials to come in. I'd like to welcome Mr. Patrick Ho, Deputy Secretary for Financial Services in the Treasury, Mr. Sin Yu, Principal Assistant Secretary for Financial Services in the Treasury, Mr. Phyllis Poon, Senior Government Counsel, and Ms. Emma Wong, Senior Government Counsel. Welcome. This part of the agenda is an introduction to the bill by the administration, and after that, members may wish to raise questions. Mr. Ho?
出席呢個會議，咁我哋作一個簡單介紹先啦。咁然之後就歡迎有關嗰個嘅政策嗰方面嘅。
Okay, first we will make an introduction, and then we can take members' questions. This bill is about our trust law, and the 2 ordinances have not been subject to major amendments since the enactment in the 30s. And we need to modernize the law, and the trust industry proposed a basket of recommendations for the reform in 2007, and then there were 2 subsequent consultation exercises, the purpose of which is to have regard to modern day trust business and make some improvements to make our trust industry more competitive, and also to enhance our status as a hub for the provision of trust services. And as mentioned in the legislative brief, this is about the 2 ordinances, and on top a lot would rely on the common law, and through the bill we'll codify some common law rules, or also to amend some common law rules, so that through codification we can provide clear provisions to the trustees and asset managers that we have make some changes to our trust law, and they would be in a position to know clearly what they are expected to comply with if they conduct their business in Hong Kong. As for the bill itself, we'll be talking about things such as default powers of trustees, and also the enhancement of protection for beneficiaries, and also the reserve powers of settlors, and also rules that would prevent the failure of the trust due to a certain disallow reserve powers. And we also have something about provision against false heirship rules, and abolish the rules of against perpetuities, and we'll be changing the rule against excessive accumulations of income. And clearly, we will not cover other aspects, including the common law rules with respect to how a trust is constituted, and who is to be regarded as a separate trustee or beneficiary. These will be outside the scope of this current bill. Next, I would ask Mr. Yu to talk about the major legislative proposals. Mr. Yu, please. Thank you, Chairman. As Mr. Holt has said, our legislative proposals cover a number of areas: enhancing trustees' default powers, enhancing protection for beneficiaries, and also ensuring the validity of certain trusts. And technically, we are also going to abolish the rule against perpetuity and change the rule against excessive accumulation of income. And here is a brief introduction of all these proposals. Maybe I should say this first. Most proposals in this bill are applicable to trusts set up before and after the commencement of the amendment bill. But the situation differs with individual proposals, and I will be specifying those when I come to those proposals. First, enhancing trustees' default powers. Modern trusts are very complicated, and sometimes the trustee may not have all the power or experience to deal with all the matters to protect the interests of the beneficiary. For example, in relation to the appointment of agents, nominees, and custodians, the present rules are very restrictive. For example, for Hong Kong assets, the trustee can only delegate administrative duties to agents. He cannot delegate or entrust the investment power to agents. Because of such a restriction, the trustees may not be able to make the best decision to protect the interests of the beneficiaries. And in other words, the beneficiaries' interests may not be safeguarded to the best extent because of the restriction. So we are going to relax this restriction, in that the trustees will have a general power to appoint agents, nominees, and custodians, although there will also be some restrictions. For example, for non-charitable trusts, the trustees cannot delegate certain functions. The most important functions must be exercised by the trustees himself. For example, distribution of assets to beneficiaries, appointment of other trustees, and also delegated powers must be delegated by the trustees. we are doing something along the line of the UK and Singapore. As for power to invest, power to insure. Well, there are certain limits to the default power of trustees to insure under the existing rules. For example, the insurance can only cover loss or damage by fire or typhoon, and not in relation to other risks. And the amount insurers can only be up to the value of the property at the time the property was acquired, but not to cover the cost of replacement. And of course, these are subject to trust documents, and the default powers will only be applicable if there are no suitable stipulations in the trust documents. But such restrictions are already outdated. So we'll be providing the default power to insure for the trustees. And in paying for insurance, the trustee's power is limited in that it can only use the income of the trust to pay the insurance premium. We see no reason why the trustees cannot pay the premium through deploying or using the asset of the trust. As we have said, modern trusts are getting more and more complicated. We believe some trusts should better be managed by the trustees with expertise and knowledge, so as to protect the interests of beneficiaries. In the law and under the common law, when it comes to receiving remuneration of trustees, or by trustees rather, there are certain restrictions. If the trust documents make no such, trust instruments make no such authorization, then trustees cannot receive remuneration generally, or they cannot receive remunerations other than for professional services. Under the bill, we are going to relax this rule, and trustees will be allowed to receive reasonable remuneration. But there are also checks and balances. If we're talking about single trustee, then that single trustee cannot receive remuneration. And if there is more than one trustee, then remuneration can only be received with the consent of the other trustees. And this is really about a default power. If the trust instruments make it very clear that the trustees cannot receive remuneration, then notwithstanding default power, then no remuneration can be received by the trustee.
Well, this provision is in line with those of Singapore and the UK. Next, the default investment items and scope of authorized investments. If the trust instrument does not specify, it does not provide any specific provisions, the trustees may invest any trust funds in only the authorized investments specified in Schedule 2. We've heard some views from the trade who told us that there are too many restrictions in Schedule 2, so that there are too much constraints when investments are being made, and that we may not be able to come up with the best investment decisions to help the beneficiary to get the best return. We've also considered that this schedule may not apply to all trustees. That is, trustees acting in their professional capacity, or for trustees who are family members. So we believe that we shouldn't relax the Schedule 2 too much, so that the trust assets will be subject to too much risk. Having considered the views from the industry, we've now proposed some limited relaxations. In respect of shares, we propose to lower the market capitalization of shares from 10 billion Hong Kong dollars to 5. The original provision is that it is required that there is a 5-year dividend requirement and we now made the relaxation and change it to dividend requirement in any stream of the previous 5 years. So we've actually expanded the scope for default investments. We've also considered certain investment products such as structured products, which the risks of which are very hard to predict, and therefore we think that it is not appropriate to allow that, and therefore in Schedule 2 we stipulate that the permitted investment does not include these structured products. If in the trust document it is stipulated how the trustee can make investments, then that should have precedence over the requirements under the provision. We also propose appropriate checks and balances. First of all, statutory duty of care of trustees. For the trustee, administers or manages the trust, there is already, a duty of care provision. We now propose that we would add this standard. That is, we have to consider the expertise and professional background of the trustees, and if the trustee were in business or exercising his acting in a professional capacity, and if any outsider have a reasonable expectation of such a person, then the standard should also apply to the trustees. So there are standards which apply to the trustee, and also if he acts as in a professional capacity, then it is reasonable to expect a person acting in the course of the kind of business should satisfy such standards. The second requirement is the exemption clause for statutory control on the exemption clause for trustees. Given that more and more trusts nowadays are very complicated, and many trusts are actually entrusted to trustees acting in business or in their professional capacity, and also these trustees would receive a remuneration. In our previous consultation, many people told us that these trustees acting in business or in professional capacity, when they receive a remuneration, their clients or the beneficiaries should have a high expectation of such trustees. We therefore believe that it's not appropriate to allow these trustees to allow for wide exemption clauses for such trustees. Under the common law, there is only the exemption clause will not be valid in the case of fraud. Having consulted the inputs received during our consultation, we propose to include in the bill 2 additional requirements, that is serious, that is willful misconduct or gross negligence. That is even if there is willful misconduct or gross negligence, the trustee will still enjoy the exemption, but according to our proposal, this will no longer be the case. And this arrangement will also apply to some existing trusts, because in the trust document, certain wide exemption clauses are already included. We believe that we should allow some time for the trustees to come up with the necessary arrangements. So in respect of this proposal, 1 year after the commencement of the bill, this new provision will come into force. Thirdly, in the bill, we will provide for trustees to appoint agents, nominees, and custodians. And in respect of such powers to make appointments, we've also provided for some checks and balances to ensure that the powers are exercised properly. First of all, when the trustee appoints such agents, nominees, and custodians, the trustee has a duty to review the performance of the agents and the arrangements relating to the trust. And for asset management functions, including investment functions, the trustee has a duty to provide to the agents clear guidelines. And when appointing the agents, they should exercise the duty of care. And when, for example, assets are distributed to the beneficiaries, the trustee cannot delegate such functions to other persons. Another proposal is in respect of the beneficiaries' right to appoint and retire trustees. Under the common law at the moment, if the beneficiaries of full age and capacity are entitled to the trust property, may act together to terminate the trust through court proceedings, so that they will be able to obtain all the assets. However, we believe that there could be some measures to help them manage the trust. For example, for such types of beneficiaries, if they don't want to terminate the trust, however, they are not satisfied with the performance of the trustee, then the bill proposes that they can actually dismiss the trustee and appoint a new one by way of a court-free process. I'd like to emphasize this would only apply to those beneficiaries who are of full age and capacity, and that the trustees have the absolute power to enjoy the trustees before they can go for a court-free process. We have some other technical proposals to further enhance the system in order to attract more people to come and set up trusts in Hong Kong. Our first proposal is to reserve power by settlers. Under the common law, the settlers already, where at the time of setting up a trust, reserve certain power to himself, for example, the power to decide on investments. This is allowed under the common law so long as the power reserved is not excessive. Then the validity of the trust will not be affected. However, we note that in Singapore, they've introduced a statute specifying that the trust will not become invalid because the settler reserves certain powers to make investments. We've heard from the trade that if we were to include this provision into our laws, it can help encourage more settlers to set up trusts in Hong Kong, because the validity or of the trust set up in Hong Kong will be further enhanced. And also this is allowed for in Singapore. We therefore propose to include this provision specifying that if the settler reserves the power to make investments or asset management, the trust will not be voided because of that. Next, abolition of the rule against perpetuities. To put it simply, the rule against perpetuities actually are quite common in the civil law jurisdictions, such as France or some Islamic countries. The rule states that if a person passes away, part of his estates must vest in with his family members, such as the spouses or children. If the estate is not enough to satisfy such requirement, there are some suggestions that if the person has set up a trust before he dies, then his family members may, through the court, recover the assets of the trust. And we've also made reference of the experience in Singapore, And in this regard, we've also engaged a consultant to undertake a study. The conclusion is that we should include is a provision saying that trusts managed under the laws of Hong Kong, then we propose to abolish we will enhance the validity of the transfer of assets for such trusts. And the trade has told us that such provisions can help the settlers to set up the trust in Hong Kong. Another technical proposal is in respect of the provision against forced heirship rules and the rule against excessive accumulation of income. Under the common law, there are some restrictions. For example, for the for the rule against perpetuities, the estate must vest with the beneficiaries within a specified period. In the law now, at the moment, it shouldn't exceed 80 years. For the rule against excessive accumulation of income, there is a very complicated rule stipulating 6 scenarios, under which specifying how the income should be accumulated. We've looked at overseas experience, and during the consultation, we heard that the abolition of the rule against perpetuities and excessive accumulation of income are already outdated. Given the complicated nature of the provisions, the trustees are faced with a very difficult situation in dealing with the trust. We therefore propose that both the RAP will be abolished. In other words, a perpetual trust will be allowed to be set up in Hong Kong. The trade welcomes this proposal because it believes that it can attract more settlers to come and set up trusts in Hong Kong. Regarding the REA, the rule against excessive accumulation of income, with the abolition of the RAP, we also propose that the REA be abolished. But given the charitable trusts are unique in nature, although we have no evidence to show that this scenario may arise, but just to be prepared for any eventuality, and given the charitable trust has a specific purpose, therefore we propose to retain some of the restrictions of the RAP and REA for charitable trust. For example, the restriction against excessive accumulation of income should not exceed 21 years, after which the proceeds should have to be used on the charity specified. So these are the major proposals in the bill. We've mentioned earlier that we have what we propose are in line with the practice in the UK and Singapore. For example, in the UK and the Singapore, they do not allow for perpetual trust, and some of our other proposals, such as the beneficiaries having the power to appoint and dismiss trustees without going through court procedure, this is only found in the UK but not in Singapore. As for the RAP and the REA, this is only found in Singapore and not in the UK. As for our other proposals, even though they may not be superior to those in the UK, they are already on par with those in the UK and Singapore. But regarding the preset investment, the scope of investment, in Singapore and the UK, they've already changed the requirement. They will give the trustee a general power to make investment. That is, in respect of the investment products, there are no restrictions. When we conducted our review, it was done immediately following the financial crisis, and having considered that context, if we do not allow any restrictions for the type of investment products, that may not be desirable. And during the consultation, many people propose that we should keep the restrictions on investments in the existing Schedule 2. So what we are proposing is slightly different from the practice in the UK and Singapore.
Thank you. Any supplement from the administration? If not, then the floor is open for members to raise questions. Mr. Ronnie Tong. But the amendments cover a very wide range, and many are technically complicated, legally speaking. I would like to get some immediate response to some of the issues I would like to raise, but some other issues will require more in-depth discussion. Let me raise my questions, which I would like to get some preliminary or immediate response, and that is there's no time limit with regard to the amendments. What about jurisdictional restrictions? How do you deal with trusts set up in different jurisdictions? To what extent would they be subject to the new amendments? In other common law jurisdictions, Commonwealth countries, more and more people are of the view that professional trustees and lay trustees should be treated differently in terms of remuneration, in terms of responsibility, and also in terms of statutory duties towards the beneficiaries. Will the administration do something to distinguish, to tell apart, to distinguish the two groups, the two different types of trustees? You said one of the reasons why the scope of investments cannot be further relaxed is because of the existing of lay trustees. And you're also going to introduce some provisions to codify the common law. Will this increase or reduce the statutory duty of trustees? And also, you mentioned that there will be certain rules for exemption clauses, and only willful misconduct and gross negligence would render the exemption clauses invalid. But what about acts contravening principles of trust? And you're also saying that you're going to allow beneficiaries to appoint new trustees. This is going to be controversial. If the trust instrument stipulates that trustees cannot be replaced, or beneficiaries cannot appoint trustees, would the trustees or would the beneficiaries be allowed to do this? Because we have family trusts with such restrictions. Not that the settlor doesn't trust the family members, but the concern is that when the family members are of age, they would spend all the money in the trust. So that may be a concern on the part of the settlor. If you give the beneficiaries an absolute right to appoint trustees, that may not be a good thing. Who will take these questions? Thank you, Chairman. I thank Mr. Tong for his questions. Let me try to answer concerning jurisdictions. Hong Kong trust law governs trusts that is governed by Hong Kong law. That is to say, at the time the trust is set up, if it states that it's subject to Hong Kong law, then our trust law would apply. But if the trust instrument doesn't mention the jurisdiction, then it would be outside the scope of this current bill. The facts of the trust were to be considered before a decision can be made about which jurisdiction should govern the trust law. And if the court is of the view that Hong Kong trust law should apply, then this bill will apply. So if it's explicitly provided in the trust instrument, then it would be as stated in the trust instrument. If not, then we'll look at the facts. As for the distinction between the professional trustees and lay trustees, well, in different proposed amendments, we have already paid regard to trustees acting in business or in the capacity of a profession. For example, duty of care. If the trustees acts in the course of a business or profession, and if there's a reasonable expectation that the person acting in the course of that kind of business or profession, then the statutory duty of care required will be of a higher care level standards. As for exemption clauses, that will only apply to the professional trustees or trustees acting in a business or profession. We are going to relax the rule on remuneration, and again, that only apply to the trustees acting in a business or profession. So in all these recommendations, we have already considered the difference between professional trustees and lay trustees. As regards whether we are going to increase or reduce the trustees' statutory duty, well, under the common law, in relation to statutory duty of care, there is also a duty of care requirement. Of course, the precedent cases may use different terms to describe the duty of care. We believe that the statutory duty of care we propose is more or less in line with the common law duty of care. We are also mindful that there are cases in the UK that for trustees acting in the course of business or profession, they should be subject to more stringent requirements. So the proposed recommendations is, in our view, in line with English precedent cases, and we are not trying to either increase or reduce the duty of care of trustees. And sometimes there are explicit provisions to change the statutory duty to be taken up by trustees. For example, that we are going to relax the beneficiaries' rights to appoint trustees. That would be more relaxed than that under the common law. As for exemption clauses, a statutory control on exemption clause, that is, the statutory control enhances the control under the common law. Originally, under the common law, the control is only imposed in case of fraud, and that is the exemption clause will only be invalid in the case of fraud. For trustees acting in a business or profession, we believe this is too lax. So we have taken on board two more elements: willful misconduct and gross negligence. And exemption clauses will be void in such cases. Of course, we have to pay attention to the trust instrument. If the requirement is very high, it's higher than the statutory requirements, and that is to say the trustees will be accountable in all cases, then the trust instrument will prevail. This default statutory control would only be applied in case the statutory instruments does not provide for this. If the trust instrument has a higher requirement, we are not going to affect it. As for change or appoint new trustees, maybe I haven't made myself clear. Again, this power is subject to the trust instruments. The scope is finely defined. Of course, we are talking about all the beneficiaries who are of full age and capacity, because they are absolutely entitled to terminate the trust and get the property in the trust, given that they have already got such an extensive power. Then we have to pay attention to the trust instrument. If the instrument says no, the new trustee can be appointed by the beneficiaries, then the beneficiaries cannot do this. Maybe there is another third party who is given the power to appoint new trustees. For example, a more senior family member in the family. Then we'll have to ask that person to see if he's willing to appoint a new trustees. Or in the absence of such provisions in the trust instruments, then the beneficiaries will be able to appoint new trustees under the new statutory provisions. Mr. Chan Kim-po. Thank you, Chairman. Of course, I welcome the amendments, because the trust law has not been amended for years. If you think that after the amendments we may be able to cope with the needs of the trust industry in the coming 5 to 10 years, well, the trust industries, as I understand it, would like to see the amendments implemented as soon as possible. And it's difficult for you to take on board one or two more recommendations in the course of this exercise, because they are very concerned that if we propose new changes, the whole process will be delayed. They support the bill and they would like to have it enacted ASAP. But if we look further ahead, we need to take into account certain matters, and there are two areas of concern which we must do something in the near future. For example, non-charitable purpose trust, and also reserve power of set laws, wider reserve power of set laws. If we can do both, it would be very helpful according to the trust industries. And the next exercise don't have to wait for another 10 years. You can look at these two issues in the next 2 years or so, and maybe some minor amendments can be effected. It would be very helpful as well. So what does the administration think about these two very useful additional amendments? Well, we have considered this, actually. Looking ahead, but we're not going to wait for decades before we do another round. That's because of some legacy problems.
Hong Kong has positioned itself as an international financial center and asset management center that is not disputable. So on that premise, we have a duty in future to review the provisions in the not distant future. We've also reflected this to the ministry. We have undertaken that we will not do it, have this round of amendment and leave it to the next generation for another round of amendment. So we'll keep in touch with the trade. For example, regarding the proposal to give wider reserve power for the settlers, I think what we need to consider is whether under the common law if there is a controversy under a provision in common law, if we were to come up with a very forward-looking amendment, it may result in we might be counterproductive. So we have to consider that. I think, meanwhile, we're not too clear about the pros and cons, and the trade will need to continue with us, continue to look into this with us. So therefore, we're not able to come up with an amendment in this regard this time. Another more fundamental issue is about non-charitable trust. I think we have two considerations here. First of all, in all the major common law jurisdictions in the world, there is no such provision. If we were to do it, we would be leading the world, but we must be careful as to why this is not practiced in other jurisdictions and why we are now thinking of coming up with this proposal. So I think that the our major concern is that at this time, and in the context of the international global economy, I think you remember that both the G20 and the IMF, especially there have been discussions in other jurisdictions about issues relating to tax evasions, bypassing financial regulations, hidden assets, and so on. Under the common law, any trust should provide for clearly stated beneficiaries. But for the non-charitable trust, the beneficiaries are not very clear. There might not even be any beneficiaries. So in the current discussion, one of the biggest problem is how we can tackle all these allay all these concerns. So because it might be counterproductive. So we need to proceed with caution. So we've told the trade about this, and we also like to say this to members. We understand the trade would like us to be forward-looking, but at the same time, since there is no such requirement in any of the other jurisdictions, and we also understand that Hong Kong is very much affected by the external global environment, and we are closely monitored. So we need to act with caution. Therefore, it might take longer for us to consider that proposal. Regarding the reserve power, I don't think there's any problem in principle, except that the question is how can we come up with a compromise scenario, and that would take time. Chairman, I'd like to follow up on one point. Patrick said that in the not too distant future you will be making a review. Do you mean 1 year, 2 years? I'm sure you do not mean 3 years. Could you give us a footnote as to when you will conduct this review? Chairman, it's difficult for me to commit to a specified date, but after the bill becomes law, then we will need to promote this. Both the government and the trade will need to promote this. We'll see how these amendments work and whether or not they are counterproductive. For the things which the trade want us to do, we will continue to maintain the dialogue with the industry. And of course, we also, after the implementation of the bill, we want to look at how they work in the next 2 years. So if I were after the commencement of the bill, I think roughly about 2 years, we will need to start the review. Even the exemption clause, they will only be implemented 1 year later, and it would take, I think after 1 year you would be able to obtain feedback from the trade. Thank you, Chairman, for reminding me of this point. Next, Mr. Kwok Wing Hung. Chairman, Mr. Ronnie Tong already asked a question regarding the exemption clause. We've also reflected this to the Bureau. That is, even if you were to use the Jersey and Gurney model or standard to define the exemption clause, the present draft is problematic from the legal angle. Gross negligence, we believe the term is not clearly defined in law. for gross negligence and willful misconduct, how do we differentiate between these two concepts? Willful misconduct and gross negligence. Legally, these are not clearly defined terms. The Bar Association has suggested that the gross negligence should be replaced by reckless acts, and because that would be a lot clearer, So, does the DFJ would like to comment on that? Chairman, earlier it was suggested that a reckless act should be used, the term reckless acts. We've actually considered this very seriously. We've considered adopting this term. Earlier on in 2012, during the consultation, we also proposed that we could use the term reckless act. But the inputs that we have received, many of the respondents told us that the term reckless act is actually a concept in criminal law. And they said that we were to apply this concept in criminal law into the trust law, because the trust law deals with civil cases. So applying a legal law, a criminal law concept into what would be a concept under criminal act? Reckless act. No, it's not just limited to criminal law. But that's what the trade told us. Well, this is one of the submissions that we received. And they told us that gross negligence, the concept of gross negligence, it's a concept that they understand very well. In some of the better trust documents, this gross negligence is a term that they are familiar with. Under the laws of Hong Kong, gross negligence has been used as well. So we've conducted our consultation, and we do not propose that we should provide a more detailed explanation or definition of gross negligence. Perhaps we can leave it to the court on regarding the interpretation or the of this concept. Because how do we define serious negligence? I think we should leave it to the court. As for the gross negligence and willful misconduct, my understanding is that the difference is with the mens rea, whether there is a deliberate intention or whether or not it was only negligence. Well, I've already made my point, and the administration also has clearly stated its position. We put forward this proposal because the professionals, like the accountants and the lawyers, if they commit a negligent act resulting in losses on the part of the clients, they have to bear the legal consequences. And these professionals will need to acquire professional indemnity or insurance. Under the new provisions, I'd like to ask this, for the professional trustees, must they take up insurance, professional indemnity coverage? Thank you. At the moment, obviously we want to regulate the trustees, but there is no requirement for them to take up insurance coverage. Of course, we do not restrict them from doing so, but the law does not require them to do that. Is it required for these professional trustees to take up insurance coverage? If not, and while at the same time they are charging a fee for the service. So I think well, they have this safeguard which is different from other professionals, and they enjoy an indemnity. Is that problematic? Also in Hong Kong, we don't have a statutory body to regulate these the professional conduct of these professional trustees. So will we be introducing a category of persons called professional trustees, and will this pose any risk to the small investors? Administration. I think our starting point is the same as Mr. Kwok's. What we want to do is to step up the restrictions in respect of indemnity in order to protect investors. Under the common law, the exemption only will not apply in the case of fraud. And in this regard, we already have included willful misconduct and gross negligence. In the past, when someone commits an act of serious negligence, they will not have to be liable. Under the proposal in the bill, gross negligence and willful misconduct will no longer be allowed, and we believe that this already increased protection for the beneficiaries. Chairman, one more point. Many accountants and lawyers, or even bankers, hope that in future they can take up the work and business of professional trustees. For lawyers and accountants, if you commit a negligent act, you'll be sued. But if you wear another hat, you act in the capacity of a professional trustee, then you will be able to enjoy the exemption according to the trust document and say you were just negligent, and you don't have to show the consequence. Sometimes the lawyer and the accountant, in the course of their work, and when they commit a negligent act, and they say, well, I'm acting in my capacity as a professional trustee, and therefore I don't have to bear any of the legal consequences. Well, that scenario might arise. Furthermore, the trustee is not covered by insurance, and they're not regulated. I think this is a problem area. Anything further from the administration? Mr. Kwok said that under the whole trust system, if we are to do everything from scratch, that's a different story. But if we come back to reality, looking at the operation of the trust industry, Mr. Kwok is a lawyer. I'm sure you know that under the common law, we are now attempting to step up the regulation. So the difference between us and Mr. Kwok is that Mr. Kwok is actually comparing apples and oranges. That is, for the same person, if he uses his professional expertise to provide a different type of service, and since the trust law has been in operation for so many years, and therefore we do not want to make that comparison because we're talking about two different systems. What we propose now are already moving towards the same direction, that is to further enhance regulation. Deputy Chairman. I'd like to ask a question regarding the perpetuity rule. The proposed amendment already exceed those of the UK and Singapore because you propose that you would allow permanent trust. What is the policy consideration behind this? When I study law, I remember that we have this rule against perpetuities because you don't want someone who has already passed away a long time ago to continue to control the estate, because we want the estate to go back to the community after a period of time. I also have another technical question. If you have an old trust, and
the trust stays a certain period, and after the amendment bill is enacted, would that period be extended automatically? Can I get some elaboration here? Thank you, Mr. Leung, for your questions. Mr. Leung's understanding is in line with ours. This rule against perpetuities was formulated precisely because people wanted to prevent properties, especially landed properties, be forever held up and could never be used for more beneficial purposes. So we have taken this into account in our current exercise. We have to look at the land system. Our system is different from that of UK. Hong Kong, we have leasehold properties, and after the end of the lease, the land can be released for other uses. And this is not quite the same as the UK. Well, in the UK, the rule was meant to prevent properties being held up in perpetuity. Well, we have actually sought advice from some experts. We don't see a serious problem that some trusts are trying to lock up properties for a long time. And we don't think that by abolishing the rule against perpetuities, we're going to see a lot of such trusts locking up properties forever. We've consulted the practitioners, and they think that this rule is not very useful in our situation, in our systems, so we propose the abolition of the rule. And the rule against perpetuities may have a bearing on the validity of the trust. Because if the trust violates this rule, the result is that the trust is invalid. And the consequences can be very significant. Therefore, we would abolish this rule against perpetuities, and the provision will only apply to new trusts after the enactment of the bill. Old trusts will still be subject to the rules at the time the trust was established. Other common law jurisdictions still have this rule against perpetuities, 125 years or 150 years under this rule. If we have a trust instrument subject to Hong Kong law, but some of the properties are the land in the UK or in Australia or New Zealand, and since we allow perpetual trust, would the properties under the trust be affected? Would the validity of the trust be affected? Say if it holds a freehold land in Hong Kong and that's under Hong Kong trust, would that be okay? Have you talked to the legal experts in other jurisdictions on whether there is going to be a conflict here? Chairman, maybe I will have to seek advice from the Department of Justice. Can you revert to us with a response later, after the meeting? Next, Mr. Paul Chair. In answering a question on RAP, Mr. Yu said, having considered that there are existing trusts which may be rendered invalid because of this, I don't quite understand the logic.
本來呢個咁嘅信託係有 RAP 嘅話咧，佢已經
If the original trust goes against the RAP, it's not a valid trust to start with. And if there's a new bill abolishing all restrictions concerning RAP, then there's no impact on existing trusts. I just don't understand the point. Even if with no retrospective effect, there's no impact in my view. It's not going to affect existing trust. And some of the provisions may apply to existing trusts. Some would apply to trusts created afterwards. Are we clear which would apply and when? And whether some would be applied retrospectively and some will only apply to new trusts? Are we clear about these? And another thing is that in paragraph 6, is stated that it's not going to affect common law rules on the constitution of and validity of trust under common law. Is it they are too complicated, so you would not touch them, or are there policy reasons? For example, when we talk about the BST, buyer stamp duty, the government insisted that no exemption will be provided to Hong Kong companies. Trusts are very transparent. We know when a valid trust is validly constituted and when it's not valid. I think we should take the opportunity to change the mechanism of constitution of a trust. It would make it more transparent. Why is it that you would leave these common law rules concerning the validity or constitution of trust this time? This is a big subject. It's a very fundamental question. We are a common law jurisdiction. We would have to make reference to common law jurisdictions. So that's where we are. We have not considered changing the fundamental fabric of trust law, the common law. We are considering the major features, and then we'll consider people in business may be attracted because we are more proactive and we are more facilitating. BST is not a consideration here. We are not trying to compete with some offshore centers. We would like to act as a international financial center. So the basic rules are not going to be amended. Why don't you codify haphazard rules, common law rules on trust, so that our trust law can be more competitive and clearer? But we have done that, Chairman. We have explained that some of the recommendations are about codification, but some are about amendments, but we're not touching the basic principles. So we have already done that. If members want to propose some other things, please give us some examples. We have considered views from the industry and the situation in UK and Singapore. So you have taken on board those practical issues. Yes? Chairman, concerning RAP, maybe I can say a few more things. Under the common law, rule against perpetuities will be subject to amendment in the current bill. Whether a trust goes against the RAP is subject to a monitoring period. For example, if the trust is for a grandchild, but the grandchild is just a contingency. The settlor doesn't know whether there will be a grandchild later born to his children. And if up to the deadline, up to the limit, after the period expires, there's no such grandchild, then the valid will go against the RAP and become void. If we introduce a new rule in the midst of this monitoring period, this waiting period, then we are rendering trust which would have been avoided valid. And some may have already been rendered void after the waiting period. And now, because we introduce a new rule, the trust will become valid again. So then will be disputes. And we very much like to avoid that. Because when the said law created the trust, this was subject to certain rules, and the said law was well aware of those rules, and we don't want to change the rules after the said law that created the trust. As for which amendments or which new rules would affect future trusts and which would affect existing trusts, well, the bill would specify that this rule would apply to new trusts or to all trusts. If the scope is different, then we'll expressly provide for the scope of application. RAP is not in the trustees' ordinance, it's in the relevant ordinance on perpetuities. In the second answer, you said you don't want the new rule to affect the intention of the said law. But actually, you are doing this in respect of other recommendations. You say you don't want to do this, unless you say all the new rules will not apply to old trusts or existing trusts. But that seems to be a conflict between your second and your third answer. You are talking about a waiting period. Of course, RAP has its pros and cons. There may be a view that it should be kept or it should not be kept. If RAP is considered inappropriate or not right, you should cancel this uncertain waiting period. And only if you think that the RAP is a valuable rule, then you are not trying to do anything to affect the RAP as far as existing trusts are concerned. I'm not trying to argue with you. I just want to make sure that you will not be said to be self-contradictory.
To answer your first question, the difference is that, first of all, we're talking about the validity of the trust. That is, whether the trust itself is valid. After it has become valid, then, as members suggested, we've changed some of the requirements. For example, there were not such a there were inferior protection at the time the trust was set up, or the statutory duty of care was not provided for at the time. So through the proposed amendments now, we are in fact making some changes, but not changing the intention of the said law. We always maintain that, compared with the proposed change to the power of the trustee, the intention of the said law, if it is provided in the document, that it will still override what we are saying now. For example, the default powers are default powers. If in the trust document, the trust document is silent and doesn't provide for such provisions, then our new provisions will come into force. So you may say that in some cases, because we've gone through decades, after many decades, many of the trusts set up at an early time, the trustee may not have envisaged this new scenario, and now that we're now proposing some amendments, so you could say that the scenario was not envisaged by the settler at the time the trust was set up. But we're saying that for RAP, we are now making this proposal because it affects the validity of the trust itself. I think that is very much different from the other amendments. Secondly, why do we draw a line like this? Because this can help avoid unnecessary disputes. As there are different types of trusts in existence at the moment. If we were to say that we welcome all sorts of trusts, and for the existing trusts, there might be many disputes involving many different parties who might have to negotiate or to litigate or to take the cases to the court or whatever. So that would create a lot of confusion. What we want to ensure is, first of all, there is clarity. So the trust set up before, they may say, you can't say it's not fair because we want to attract new trusts to be set up in Hong Kong. That's our purpose. And it's not a simple consideration. In the context of Hong Kong, we are able to make a relaxation, but it's not a relaxation that applies to the whole world. So we're saying that it will only apply to new trusts, and for the old trust, the old provisions still are in force. I don't mind whether members would mind if I follow up further on this point. In your answer, you said that when the trust was first set up, it was done in accordance with the law at the time. Of course, I agree that if the deed had express provisions regarding something, then the bill will not affect those express provisions. However, in our frame of mind, we're saying that if at the time the trust was set up, if they could think of all what we're now proposing now, they might have included that into the deed. So I don't understand why some provisions apply to existing trusts and some would only apply to new trusts. Are we saying that after effective date, the new law applies? That's consistent logic. Secondly, no matter what happens, we will use the new trust to govern all trusts. But you say it applies to some but not to the other. Or you say that the settler at the time had not considered this, or they may have other thoughts, they resorted to different provisions. So it's very confusing. I don't know whether I've made myself clear. I think this is a very interesting discussion. It's not a question of guessing what's on the mind at the time. If the document clearly reflect the intention of the settler, then our new proposals will not override those. I said that but the settler might have not thought of these. Having considered the different types of deeds and the complexity of such deeds, so our present draft will facilitate the operations of these trusts. Of course, if we could change, the people can change the content of the trust documents. If they want to amend the documents, they can also do that. Some people actually do that. People sometimes would amend the trust document. But the trust law is still in force, right? Well, I give up for the moment. Mr. Leung, Chairman, I'd like to follow up on Mr. Portier's question. That is, when the bill comes into effect and it becomes retrospective, if you look at a deed that was trust document written more than 100 years ago, I mean, the document could be really complicated. I hope the officials will now start thinking about whether whether this bill, when it comes into operation, will create many problems. I can tell you, first of all, that if there's an old trust document with hundreds of provisions, you will find that there might be 4 scenarios regarding these provisions. First of all, if the old trust document is silent on certain things, then you may need to follow the requirements under the amendment bill. That's scenario 1. Scenario 2, in the old trust document, there's something expressly written down which can override the provisions, the new amendments, because under the new amendment, certain things are optional. So in this case, we follow the provisions in the old document. There might be old documents with provisions regarding, say, indemnity. In this case, obviously, you have to follow the new law because indemnity provision is too lenient. A 4th scenario is this: the new amendment bill will not affect the old, the provisions in the old trust document regarding RAP. So I mean, even at the moment, I can imagine that it could be so complicated. How do you expect the trustee will understand how this amendment bill is going to operate? Especially, I think the layout of your bill will need to be clearly done. Otherwise, like Mr. Chair said, you would apply the new provisions to all deeds, irrespective of the time they were made. Or if the bill only comes in existence after the bill comes into effect, then the provisions only apply to those new deeds, trust deeds. Regarding the 4 scenarios mentioned by Mr. Leung, the first 2 would be more common. The last 2 scenarios are really very exceptional cases. Take the last scenario, for example. You have the new provisions. Once they come into force, it will not affect the old ones. That would be the RAP. There's only a single one that I can think of. And well, regarding the indemnity clause, no matter how you draft it, we're going to have a new version. There's only a single indemnity clause. I think in the ultimate analysis, in the 3rd and 4th scenario, there's only one scenario that we can think of. Of all the scenarios that we need to discuss, what you suggest sounds very complicated, but and for trustees acting in their professional capacity, I think they in the course of our dialogue, they fully understood this. Although there seems to be 4 possible scenarios, basically only the first 2 would be common. The last 2 will only be isolated incidents. They warn a concern. The question is whether or not the new provisions will apply retrospectively to existing trust documents. Given the long time gap, I think you should really obtain some samples from the industry to see whether or not there are some extreme examples. Because after you've made the amendment, and once these amendments come into force, it might result in a lot of disputes. So if you could take that extra step, and also you can approach the professional trustees you've approached earlier to find out from them, because that can help allay the concerns raised by members today. That is, how do we deal with the possible, repercussions after these amendments come into force? So if you don't mind, now, have you considered this? When would you differentiate between trusts for where the settlers have passed away and settlers who have not? because if the settler is still living, then he might want to draft a new trust. But for those who have already passed away and you are now imposing some new requirements, it doesn't seem very fair. And secondly, could you consider providing an escape clause? If you want to enforce the new provisions, resulting in the trusts or the trustees or the beneficiaries feeling that it's unfair, is there any mechanism for them to apply for exemption from these new provisions? Administration? That is to ensure that the new amendments will not affect the entitlements which were enforced before the amendment. The ultimate question is whether or not this is retrospective. I understand Mr. Chair's first question, but Mr. Chair's second question was about exemption. When we set up a trust, there are three things, three parties, the trustee, the beneficiaries, and the settlers. And the interests may not be entirely consistent with each other. What exactly do you mean, Mr. Chair? Of course, when we talk about settlers who have already passed away, you say that a new rule would apply, irrespective of whether or not you have thought of this at the time the trust was set up. But for either it's the trustee or the beneficiaries, if they believe that applying these new provisions on the existing deeds trust is not fair, is there an escape clause for them to go to the court and apply for exemption from the new provisions? For the trustees, I dare say that we don't need to consider that possibility. The trustees, as far as trustees are concerned, it's the default power which will be affected. What we are proposing will increase the default powers. As for the other parties, whether there's checks and balance, when the trustee has greater default powers, we want to ensure that there is proper checks and balance. When we talk about trustees, I don't see how we need to consider this. And coming back to the beneficiaries, again, it would appear that the trustee seems to have more powers, but we're talking about default powers. Then if a beneficiary will need to look at the trust document and what the trustees have been entrusted to do, because the beneficiary is always at the receiving end. So I don't see how he has any locus to say that we shouldn't grant the default powers to the trustees. But when we come to a stage when whether there's a need for, well, even if the beneficiaries are not satisfied with these proposed changes, that doesn't mean that it's the same as he's not being satisfied with the performance of a trustee. Through these amendments, we want to give the qualified beneficiaries to go through a simple procedure to replace the trustee. And he can also apply to the court for the termination of the trust. So eventually, the qualified beneficiaries will have the ultimate power to terminate the trust or to replace the trustee. So in the end, he still has that protection.
So what I'm saying is that we don't think that we need to consider individual cases and offer exemption. That will lead to greater confusion. If we want to facilitate the operation of trust and we allow the different cases to be treated differently, the message is a very confusing one. I want to follow up on the answer provided. Chairman, we haven't proceeded to clause by clause, whether we're talking about default power or default restriction, or whether the scenario I have depicted would actually happen. there are pre-existing trusts, and you want to add this or that to the trust, affecting the relationship between the parties. Because the nature of the trust or the line of power or control may be affected. If it's under common law, you can go to the court to apply for a direction. But after codification, the court may not have the power to alter anything because it's subject to the codified law. Maybe there should be only bus escape route. If the parties are not happy, and I'm talking in particular about existing trusts, there should be a better and easier way out. It's not just about changing the trustees because they're subject to all the beneficiaries' consent. Have you considered this? I'm just raising this for discussion only. As I've said, Chairman, we have never considered adopting this approach. And of course, maybe we would gain a deeper understanding about what individual amendments are about when we proceed to cross by cross. If there's still a perceived need at that stage to follow up the relevant matters, we are willing to consider them. Mr. Kenneth Leung, Mr. Chen Kim-Board raised a question about non-charitable purpose trusts on behalf of the industry. Well, I want to raise a related issue, and that is that we have the concept of charitable purpose trust, which is not in the existing trust ordinance. And if you want to simplify the law, why don't you do away with the incorporation of charitable purpose trusts in the trustee ordinance? Maybe we should have regard to the Inland Revenue Ordinance, Section 88, and only those recognized under that section will be regarded as a charitable purpose trust. Maybe those provisions can be taken out and inserted here, because you have different approaches for existing and new trusts already, and then you are introducing a new dimension. The trusts have to be differentiated into charitable purpose trusts and non-charitable purpose trusts. Well, actually, this concept of charitable purpose trust is already in the Inland Revenue Ordinance. It's not just about Section 88. We have to look at the charitable purposes. And there are case law. There is case law governing what is meant by a charitable purpose trust. And we are making a corresponding arrangement here, having regard to the overseas arrangements. A charitable purpose trust is a public trust. And since it's charitable, then in relation to excessive accumulations of income, we want to make sure that there will be no excessive accumulation of income, as there are special provisions governing charitable trust. And the concept is already in the ordinance, existing ordinance. Have you make reference to the other jurisdictions such as Singapore? Yes. In relation to the remuneration for trustees, yes, we have make reference to other jurisdictions. And we have already make some fine-tuning in relation to charitable trust. So they also make a distinction. And there's no clear definition on charitable trust. So it seems that they have another piece of legislation on charitable trusts, and maybe you should not incorporate this in the ordinance. They may have a charitable law, but we don't. If we say this is a charitable trust, and the IRD says no, so what is it? I want to raise a technical point. If you want to introduce charitable trusts, maybe all the relevant provisions should be in one section for easy reference by charities. If you use an embedded approach, it's very troublesome. Can you consider this? So to avoid these possible problems, concerning the last point, the charitable trusts may want to know what they are subject to and the impacts to them. Of course, we can scrutinize the layout when we proceed to the cross-by-cross examination. We want to make sure that is user-friendly, which can use another compilation of relevant provisions for their easy reference. That may be one approach. We can find ways to make it easy for users. There are organizations with a long history. There are charities. Have you consulted them? These major charitable trusts may have employed legal advisors. What are their views about the proposed amendments? Well, we haven't received any controversial comments. As I've said, there can be many ways that we can facilitate future users. I propose that you compile some information with reference to the old and major charitable trust with a long history and try to sound out their views on the amendments. If we're talking about charities with long histories, then perhaps other bodies should also be consulted. Well, the law is complicated. Even after reading your paper, we may not know fully what the amendments are about. So perhaps we should invite deputations to tell us what they think about this. And among them, there should be a charitable trust with a long history. Mr. Ronnie Tong, I've noted that members have shown or expressed their concerns. When we talk about charitable trusts, there are two things. First, inland revenue, taxation. Second, the certainty of law and the principle to be applied. I don't think we should be concerned about taxation. It should be about certainty and certainty of charitable trust. At present, charities are governed by common law. What we are lacking in Hong Kong is sea prey. Concerning the use of charity funds, in the UK, this is done through a statute. Hong Kong has no such law. So it's a loophole, or we are lagging behind the times. We know that this time you are not going to change anything about the principles. You are going to, concerning charitable trusts, you are going to just use the common law definition. The definition adopted by the court is very different from common sense definition. Sometimes we think something is charitable, but it's not. Why is there this C-Play rule, that is to supplement the common law, to make up for the shortcomings under common law. But you are not going to intervene. You are not going to have something like the UK's C-Play amendments. So on more or less we are going to keep the basic principles concerning charitable trusts as they are. Thank you, Mr. Tong. The answer is yes. We are not going to change or touch on this subject. And you have no intention to do something like the UK or the US and set up some law on C-Play? You have no intention to do this? I can only say that within our ambit under the FSTB, we have no intention to do that. What about Home Affairs? I understand this is rather technical and complicated. I can understand why you are not going to do anything, but that's a shortcoming on the part of our law on charities. Well, perhaps later we can look at actual problems encountered. All right? If members have no further questions to raise, then we move on to AOB. The date of the next meeting will be the 9th of April from 10:45 to 12:45. We haven't been able to secure a lot of 4:30 slots. Yes, unfortunately, during that period, I won't be able to attend morning meetings. I'm not going to ask for a change of meeting date, but don't count me in. I won't be able to attend meetings in the morning during that period. Oh, please mark the time. And there are a number of other days, meeting days, which you may want to pencil. 25th of April, 10:45 to 12:45. Another slot is the 7th of May, a Tuesday, 4:30 to 6:30 p.m. Another one, 11th of May, Tuesday, 21st of May, 4:30 to 6:30, and then the 4th of June, 4:30 to 6:30. And then in the middle of June, we have the 13th of June, Thursday, at 2:30 to 4:30. Please pencil in these days. And the Secretariat has sent out letters and put up a notice on LegCo's website to invite deputations to offer comments on the bill. The deadline for making submission is the 28th of March. In due course, the Secretariat would forward those submissions received to members. And after members have read those submissions, we can decide whether we are going to receive deputations. If it's considered necessary to meet them, we would send out invitations. Okay, so this is under AOB. Anything under AOB? If not, meeting's adjourned. Thank you.
唔該，我而家